Hearing the appeal of Hassam and another, against Rabot and another.
May it please your lordships, your ladyship, I appear for the defendant insurers in both of the test cases before you. They are the appellants in the appeal and the respondents in the cross appeal. My learned friend Mr Williams, King's Counsel, appears with Mr Eastwood for the claimants in those test cases, the respondents and appellants in the appeal and cross appeal respectively. For simplicity, I propose to refer to my clients simply as the defendants and Mr Williams' clients as the claimants. My learned friend Mr Weir, King's Counsel, appears with Mr Way for the interveners in the cross appeal. The issue before this court is one of statutory interpretation. Prior to the Civil Liability Act 2018, general damages for pain, suffering and loss of amenity, PSLA, for all personal injury claims were assessed by the courts having regard to common law principles and precedent. By the Act, Parliament has introduced a radically different regime for certain, what the parties are terming qualifying, whiplash injuries. Damages are still to be awarded for PSLA resulting from such qualifying whiplash injuries, but the level of such damages is not left to the courts to assess. It is set by the Lord Chancellor in regulations. This is not just a radically different approach, but results in a radically different sum being payable for PSLA caused by those qualifying whiplash injuries. As the court can see from Appendix 1 at page 113, the tariff sums payable as damages are far lower than the common law damages historically payable.
Oh, I have to
that
say
is not in dispute.
My own experience of dealing with whiplash cases, rather like, I suspect, counsel in the front row, was rather a long time ago. And I have no idea what the common law rate might nowadays be.
My Lord, if I could ask your Lordship to turn to page 113. I have set out there in the appendix a table which has the current tariff rates alongside the final column, which is the JCJ guidelines.
It's roughly 10%.
The proportions change as we go through the table. So your Lordship can see at the bottom that for a qualifying whiplash of 18 to 24 months, one has just over 4,000, and that is a larger proportion of the JCJ guidelines sum, but it's common ground between us that the tariff amounts are far lower than the courts would award under the JCJ guidelines. That's not in dispute. That's what the Act and the regulations provide. What is in dispute is how a court is to calculate the overall damages award in so-called mixed injuries cases.
Just before you leave that table, the 16th edition is what year?
That's the year that is currently in force, my Lord. So it was in force at the time of the Act, and it's currently in force.
Right, so there's still guidelines being given despite the statutory tariff?
There are indeed, because not all whiplash injuries are qualifying whiplash injuries.
Yes.
And so there are still JCJ guidelines for what would be given for a whiplash injury. So there is a useful direct comparator there.
Thank you.
So that would be for sort of a non-road traffic act?
Either a non-road traffic act, my lady, or what we would colloquially call a road traffic act that doesn't qualify for the narrow category of road traffic act to which this act is directed. So in particular, those suffering whiplash injuries who are riding a motorbike don't fall within the statutory regime, and to them, the JCJ guidelines would still apply.
Looks like the 16th edition was November 21.
My learned friend is saying that the 16th edition is November 2021, but the key point, my Lord Burrows, is that it's current.
Thank you.
That table is agreed between us. It's not in dispute that the tariff under the Act is a considerable reduction from the JCJ guidelines. What is in dispute is how a court is to calculate the overall damages award in so-called mixed injuries cases. Those are cases where a claimant suffers a qualifying whiplash injury, and I will take the court shortly to the Act to show what a qualifying whiplash injury is, but in the same accident suffers a different injury, as has happened in both of the test cases before the court. So in Rabot, Mr. Rabot suffered both a whiplash injury and an injury to his knees, or in Briggs, an elbow injury. Now, the tariff only sets the damages for the PSLA caused by the qualifying whiplash injury. Court-assessed damages remain payable for the knee or elbow injuries. So far, so agreed. But what does that actually mean in terms of a calculation of the overall award? If on the facts, as found by the judge at first instance, there is some concurrently caused PSLA, so caused by both the qualifying whiplash and the non-whiplash injury, how should that be compensated? There are three options before the court, as summarised by the Master of the Rolls at paragraph 57 of his dissenting judgment below. And I've set that paragraph out at paragraph 5 of the agreed statement of facts and issues, which is page 81 of the bundle, the first document in the key documents bundle. Where the Master of the Rolls says this is what the case is really about. Option 1, only the statutory tariff is payable for any concurrently caused PSLA, but what a court can, of course, award in addition are judicially assessed damages for any PSLA which is caused solely by the elbow or knee injury, because that loss is not compensated by the tariff. We say option 1 is the one that correctly interprets the Act, and it's the option adopted by the Master of the Rolls. Unpacking that briefly, the Act sets the damages for the PSLA caused by the qualifying whiplash injury. The tariff is to be those damages. Such PSLA includes PSLA concurrently caused. So there is no room for common law damages to be awarded in addition to the tariff for any concurrently caused PSLA. We say that's clear as a matter of the wording of the Act, which says the tariff is to be damages for the qualifying whiplash. It's also unsurprising as a sense check, because the common law, and I will unpack this during my submissions, the common law does not permit damages to be awarded twice for the same loss. The Act substitutes one amount of damages for another, the statutory tariff for, if I can call it in shorthand, the judicial tariff. But it doesn't disapply this basic principle that there shouldn't be double recovery. It doesn't do so expressly, and there's no room for finding it does so impliedly. And indeed, if more than the tariff could be awarded for concurrently caused PSLA, simply because it was caused by a knee or elbow injury, it would run contrary to and undermine the policy of the Act, because more would be being awarded for the qualifying whiplash injury. So option 1, our approach, and that of the Master of the Rolls, is that in mixed injury cases, the court identifies the tariff for the PSLA caused by the qualifying whiplash injury. That necessarily compensates for the PSLA concurrently caused by another injury. Having found that tariff, the court then adds to it common law damages for any PSLA solely caused by the knee or elbow injury. Those sums are added together to comprise the overall award of damages. The claimant receives damages for all the injuries suffered, but no double recovery. That's option one, our option, the option preferred by the Master of the Rolls. Option two is the claimant's primary approach. It was rejected by the entire Court of Appeal below. It's advanced on their cross appeal, supported by the interveners, albeit on slightly different reasoning. Under this approach, a court takes the tariff sum and adds to it a sum reflecting the JCG guidelines for the knee or elbow injury, and the resulting total is the overall award. It is accepted that this will lead to any PSLA concurrently caused by the whiplash injury and the other injury being compensated twice. That's accepted. It will be compensated once by the tariff and once by common law damages. And that is said to be what the Act requires, not just permits, but requires. There is a difference between the reasoning of the interveners and the defendants justifying that route, which I will come to, but both say that's the option that the Act requires and that the court should adopt. I should note in passing that there appears to be an argument trailed in my learned friend Mr. Williams's written case that any double recovery is de minimis. Can I stop that argument in its tracks at this stage, please? First, with respect to my learned friend, that simply does not sit with the findings of the district judge, which are set out at footnote 2 of the agreed statement of facts and issues, which we can see at page 80. We've set out there that the district judge found that there was concurrent PSLA. And indeed, if we look through those findings, a clear overlap on the basis of the medical evidence was the phrase used in both cases. In any event, this court clearly cannot conclude that there will be de minimis concurrency in every mixed injury case. And these cases are before the court as test cases, and the premise of the agreed issue before the court is that there will be concurrently caused PSLA. The only issue is, what does a court do about it?
We need to understand. I think it's probably important that we understand what exactly we mean by concurrently caused PLSA. What's going through my mind is that you might have a situation where the two injuries do contribute to a single identifiable loss of immunity. For an example that we were discussing amongst ourselves was somebody who enjoys playing football, and he bangs his knee and he also gets a whiplash injury in a car accident. And he can no longer play football for a period of a couple of months perhaps, because he can't kick a ball and he can't move his head to see where the ball's coming from. So there you have the two injuries are indeed concurrently causing a single identifiable loss of immunity. Now, on the other hand, they may not be concurrently causing a single pain. He may have pain in his knees when he flexes his knees, and but which are not painful when he's not flexing his knees. And he may have pain in his neck when he moves his neck, but it is not painful when he's still. And so one isn't really saying in that situation they're concurrently causing a pain. but it may be that because we award a global amount for pain, that global amount compensates for the two pains.
My Lord is quite right, and quite right to pick me up. We're using shorthand terminology. Yeah. PSLA comprises the P, PS, and the LA. And on the facts of any given case, one might have a certain amount of concurrent P, a certain amount of concurrent S, or a certain amount of concurrent LA. And that's a point that the Master of the Rolls was very alive to in his judgment, where he talks about breaking down the PSLA. We are, in this appeal, referring to concurrently caused PSLA simply because we're addressing the principle here. On the facts of any given case, a judge would need to look at, well, what is it in fact that is concurrent on the medical evidence before me? And we can see that that's the approach that the courts have always taken and will continue to take, that they look at the medical evidence to see in fact where there is a concurrency. And I say they've always taken because when I turn to option 3, which is in effect saying the common law approach for dealing with an overlap, that of Sadler should continue to apply. So we can see that the courts have always had to grapple with this issue. So I hope that assists. I'm using the term concurrently caused PSLA.
So in the example that my Lord the President gives, in your option, you would say whatever compensation he's entitled to for the loss of playing football, that is compensated for by the tariff, and he gets nothing further for the knee injury for that element, but that for the pain and suffering there might be a bit additional because the knee pain is separate from the neck pain. Is that how it would work?
Milady, yes, if on the medical evidence the duration of the whiplash injury was identical to the duration of the other injury, and therefore that was why the claimant in that case couldn't play football for that period.
So would it be right to think that there might be more scope for finding concurrent causes in the case of loss of immunity than in the case of pain and suffering?
It's very much going to turn on the medical evidence in any case, because, and I don't want to pretend to footballing expertise that I don't have, but it's very much going to depend on what's the impact on that claimant of the whiplash injury or the elbow injury or the knee injury. And it would only be if they are purely concurrent, so that the knee injury is not affecting the footballing activity for any longer than the whiplash, that one is purely within the realm of it being compensated solely by the tariff. If there is any additional LA that can be traced back to the non-qualifying whiplash injury, that falls to be compensated in the same way as any additional P or S does.
I mean, it might be said against the approach option 1 that this is requiring precision in a way that has not normally been regarded as important. So the notion of concurrence has been treated in a rough and ready way by the Sadler adjustment, whereas, as I understand it, the Master of the Rolls approach is actually requiring much more precision in examining medical reports, perhaps, than has been required in the past. I mean, is that a fair assessment?
Well, with respect, we would say not entirely. Firstly, that precision should be there under Sadler, because the court under Sadler is saying as a matter of principle, there cannot be double recovery. Therefore, we are going to look at the medical evidence to identify where there is an overlap, and we are then going to adjust down from there. So there should be the foundation in the medical evidence already. But the follow-on point from that is, if there isn't, then that doesn't mitigate against this being the correct interpretation of the Act. It would simply lead to the need for perhaps greater focus in the medical reports that we see, because the practicalities with respect cannot drive which is the correct interpretation. And we say it's quite clear that Parliament intended the tariff to be all that a claimant could recover for the qualifying whiplash injury, which throws, obviously, this issue into focus. We all agree with that. And if the medical reports need to grapple with it more precisely, then, with respect, that's what they'll need to do.
Right. So you're saying that it requires quite a change from the more rough and ready.
My Lord, we're not going that far. I mean, if your Lordship turns to footnote 2 of the agreed statement of facts and issues, one can see the sort of findings that are made there on the basis of medical evidence that was put in. Those are the sorts of findings that the courts are used to making.
Yes, I agree.
And we say that that would enable the court to adopt option 1, because the judge there has looked at the clear overlap on the basis of the medical evidence, cannot discern any particular difficulty occasioned by the knee injury, and that's going to the, is there any additional LA, or are we just looking at the PS? Now, I don't press this point too far because it's agreed between my own friend Mr. Williams and I that we would both invite the court, depending on the outcome, to remit the cases so that a district judge could follow the guidance of this court, whichever option is preferred, to go through the medical evidence to make sure that the approach is a model one. So I don't press this point too far.
But that medical evidence, as set out in the footnote, then led to the Sadler adjustment. So it fed into what is still a rough and ready deduction.
It fell into
but as I understood the approach that you were preferring, and indeed the Master of the Rolls, you would have to be much more precise than that if you're going to follow it forward. But you're not accepting that.
If I can put it this way, I'm not accepting that it's an impossible task. It's going to take some refinement, we anticipate.
Of course, we've got no figures, have we? I mean, no. What the Master of Rolls did not do is say, on these facts, these therefore are the figures that I would follow through.
Indeed.
And is that not indicating it's actually going to be quite difficult to get this sort of precision?
The only question that the court will be looking at is there any additional PSLA caused? And our position is that that is a decision that can be taken by a court looking at medical evidence which clearly addresses what the PSLA is caused by each injury and considers concurrency as the medics are currently required to do.
But I think you've already said they're going to have to be so much more precise, because the medics haven't been doing that in general terms. They've been giving a general medical assessment. They've not been pinning down how much is concurrently caused by these two types of injuries. They would have to do that, wouldn't they, on the approach you're advocating?
My Lord, yes, but we would say that they should also be doing that, even if your Lordships were to adopt option 3, which is the majority approach, because the Sadler approach, given that it is now looking not just at adjusting two sets of common law damages, but adjusting common law damages and a tariff, we say that greater degree of precision should come in there as well. So I don't want I'm not resisting that greater precision would be ideal. It may even be necessary, but it's probably necessary under options 1 or option 3. That doesn't mean that the practical solution is to go for option 2, because we come back to what's parliamentary intent here.
Can I just ask you a general point as well that just troubled me, as to how these damages for loss of immunity and pain and suffering are arrived at? So let's assume we've got a knee injury, and let's assume we've got a neck injury. When one is thinking about the loss of immunity, am I right in thinking that there's an objective element that one will be looking at, which means that you will get objectively a different basic sum for a neck injury than for a knee injury? In other words, that the loss of immunity is to some extent including what you might call the injury itself. And then you build on particular loss of immunity. So the example the President was giving of the football is, in a sense, specific to that particular claimant. But it doesn't alter the fact that a knee injury is different from a neck injury. Wouldn't objectively that be reflected in a different amount?
Unpacking that, the overall sum that the court is arriving at for any injury, yes, has an objective element, but is also looking at the particular circumstances of the claimant at common law. Yeah. When one looks at the tariff, one is purely looking at one factor, the duration of the injury. So the degree of pain and suffering that a claimant suffers is not taken into account under the Act unless one gets into the uplift scenario
But what I think I'm putting to you is that on the way we've traditionally thought, as I understood it, of the assessment of PSLA, and that it does include what you might call objective loss of amenity linked to a particular injury. That seems to me how the guidelines have always been understood. You are never going to have complete concurrence on loss of amenity, because it always means you're talking about a different injury. There will always be some, it may be very limited, but there will be some difference between loss of amenity, i.e. including the injury itself, for a neck injury than for a knee injury. Is that incorrect or correct?
Lord, no. We don't disagree with that. There will be, on the facts of any given case, some degree of concurrency, but also some degree of non-concurrency, which is unique to the nature of that injury. And what the court has always been concerned to do is to ensure that it properly identifies what's concurrent, where the overlap would be between awarding damages for two
So when the Master of the Rolls implied here that there was absolute concurrence between the loss of amenity, he seemed to be regarding District Judge Hennessy as saying that was arguably slightly going too far, because what the district judge was talking about was particular loss of amenity, what you might say some sort of special peculiar to the claimant?
Lord, not just the special loss of amenity, but also looking at the objective loss of amenity as your lordship described it. So looking at what's the effect to this claimant footballer on the facts. We don't read the Master of the Rolls as saying there was on the facts no separate loss of amenity caused by the knee or the whiplash injury. That, as your lordship has said, we cannot see worked out in the numbers which the Master of the Rolls would have awarded. The issue before the court today is assuming that there is some concurrency and also assuming that there is some non-concurrency. So there will be part of the PSLA left over, if you like, for that non-qualifying whiplash injury to be compensated by common law damages. The issue is how the court integrates the two, and the practical concern that I'm grateful my Lord Barrows has raised at the outset, that this might require a tightening up of medical examinations and medical reports, we say shouldn't drive the court finding which is the correct interpretation.
In terms of P&S, isn't it generally going to be separate P&S for separate injuries? And a medical report will look at it in that way?
There may be some separate P&S, there may be some overlap in P&S. That's very much going to turn on the medical assessment in the individual case.
When you, I've just been looking at the medical reports.
Lord, yes.
And what the doctors do in these medical reports, the two we have, is they report the history narrated by the patient and the symptoms narrated by the patient. They measure the range of movement of the relevant part of the body and compare it with a normal range of movement and express the difference. And then they give a prognosis as to the likely timescale for the resolution of symptoms so far as they're going to resolve. But when it comes, they don't attempt to allocate pain to particular injuries, I don't think. And in the case, for example, of Mr. Rabot, when it comes to loss of amenity, we're told that what he reports, according to the doctor, is, for example, difficulty carrying heavy items, difficulty putting out the dustbins, and the like. Now, the doctor isn't expressing any view at all as to whether his problem putting out the bins is because of a immobility, whether there's a restricted movement of his neck, a restricted movement of his knees, or a combination of the two. And likewise for the other complaints that would go towards a loss of amenity award. So either one would have to ask doctors to give a different type of report, which did try to express a view as to the link between particular injuries and particular complaints, or you would need to get the doctor to give oral evidence and put this to it, to take it from him in his evidence.
Lord, in these types of cases, clearly we're not urging as an option on the court that is going to require medical evidence and cross-examination of medics. So it will be the first of the approaches that your lordship raises, which is it will require a tightening up and a refocusing of the questions that the medics are addressing. However, I do come back again, and apologies for repeating it, but I do come back again to 2 points. Firstly, the practicalities shouldn't drive which the court finds to be the correct interpretation of the Act. If practicalities need to change in order to implement it, that's the right way round. And secondly, even under the third option, we say that the medical reporting will need to tighten up anyway, because the third option, if I can come to that, which is that of the majority, is one which recognises the double recovery that would result from awarding the tariff sum and common law damages, finds that that is impermissible, and finds that the way to deal with it is not the build-up approach that we urge under option 1, but a Sadler-type adjustment. For that Sadler-type adjustment to be done with any precision, given that we would be in the realm not of adjusting common law and common law basis damages, but common law and tariff, the medical evidence would need to tighten up for option 3 as well. That is not, I stress, to urge option 3 as the correct one or a practical way out in this appeal. Because
I have to say, at the moment, I don't quite follow that argument. I mean, I can understand an argument that said the way in which common law damages deal with overlaps is not precise enough. Mm-hmm. One ought across the board to be applying Sadler in a much more precise way. And I could understand that argument, but I cannot at the moment see why the new whiplash legislation requires any more or adds weight to the argument for applying Sadler more precisely than it would do at common law.
Well, Lord, it may be that Sadler across the board should be applied with more precision, but it particularly comes into sharp focus in this case because of the difference in bases between the tariff amounts and the common law damages. So the common law damages is the sum that the court considers fair, just and reasonable. The tariff sum is that which is considered proportionate from time to time by the Lord Chancellor. So any room for imprecision that may be more acceptable when one is comparing like with like doesn't work, we say, when we are adjusting under the majority approach the tariff sum and common law damages. And it's an approach that the Master of the Rolls said was unprincipled, unscientific, as well as simply wrong as a matter of interpretation. That is a critique adopted by my learned friend Mr. Weir for the interveners, and it's also the majority approach said to be wrong by my learned friend Mr. Williams on his appeal. His enthusiasm for it, if I can put it this way, is somewhat muted. He adopts it as his fallback argument in response to my appeal, saying it's at least preferable because Parliament will have made some reduction in the award, even though it's imprecise and doesn't properly or scientifically deal with the overlap. And we say that actually highlights the flaw in it, which is why neither we support it nor the interveners support it. And of course, what this court is concerned to find is not an approach which makes some reduction in the damages for qualifying whiplash, but the approach which ensures the precise reduction that Parliament intended is achieved. And we can see, if we turn back to that table at the end of my written case, page 113, that rather than under the JCJ guidelines where there are ranges, we have, under the tariff amounts, very precise numbers. Those are the numbers to be awarded for qualifying whiplash injuries.
Under the common law, the JC guidelines, there's the range there, and is where you fit in the range, well, that will be determined presumably partly by whether it's a 3-month or a 12-month, but will that also depend on actually how painful it was, which is not something which is, as you pointed out, reflected in the Table A amount?
Milady, it will. So at common law, the court will be looking, to pick up on my Lord Burroughs' point, at the objective information, the category, but we'll also be looking at the precise impact in terms of degree of suffering, degree of loss of amenity. That is not something that Parliament has considered it appropriate to factor in when setting the tariffs. It is only duration that is considered, unless we get into the territory of an uplift limited to 20% on those tariff sums. And to get into that uplift, one needs to be in an exceptionality category.
Ms. Hitching, I can understand that the adjustment exercise contemplated by the majority of the Court of Appeal isn't strictly a Sadler exercise because you're not comparing like with like. But isn't it really a case of standing back and assessing, trying to avoid any element of double recovery?
Well, it is, and we say that the majority rightly recognised that there would be double recovery otherwise on Maloney Friends' preferred case, and that was impermissible and was trying to find a way to adjust it. But we say that the adjustment doesn't work, and therefore the better and the only way of avoiding that adjustment is to work from the ground up, to fix the tariff and then to add on to that any additionally caused PSLA.
How precise does the adjustment have to be?
Under both, we say it would need to be precise if the court is to avoid ordering more by way of damages for the qualifying whiplash injury than Parliament has permitted, because Parliament is only permitting that precise sum. So under the Sadler approach, or the majority approach, if one does a rough and ready comparison, one is not only awarding the tariff sum for the PSLA caused by the qualifying whiplash injury, one is also adding on some imprecise level of common law damages. Now, I say that with confidence that that is done in every case because of two things. Firstly, the fact that the courts are having regard to common law precedent, and secondly, because of the caveat. If I can unpack those two things. When the court, under the majority approach, is taking the stepping back exercise, it's stepping back in order to look at the overall award by comparison to something, to ensure consistency, and the court there is only looking to common law precedent because there are no precedents as yet that deal with the integration of awards between tariff and common law damages sums. So certainly at present, the court has no guidelines to look at, and we say that any existing precedents on the level of what is appropriate for an overall award simply cannot assist, because the concurrently caused PSLA is obviously valued differently by the common law JC guidelines and the tariff. In response to that, your lordships may say, well, those precedents can develop. They can, which brings me to the second problem, which is the caveat with the majority approach. The Court of Appeal's caveat is that in making the reduction, in seeking to address the overlap, the overall award for damages cannot be brought down below the level that will be awarded for the non-qualifying injury alone. That builds in overcompensation for concurrently caused loss in every case, because it means the court cannot take out the amount of overlap down to the level of the tariff sum. Because the tariff sum is sitting here, sorry to act this out, the tariff sum is sitting here, the common law damages are sitting here. If one is saying, well, we will address the overall award down to the level of the common law damages, but that's the floor, you cannot go below that, then you have built in every case some element of common law damages above the tariff sum that will be paid for concurrently caused PSLA. And that's a flaw in the majority approach.
Was this caveat argued for, or did it come from the court?
Yes. My Lord, I understand it was argued for below. I think my learned friend who appeared below and argued for it can probably explain the way in which it developed in the course of argument, but it was certainly argued for below, and is argued for in front of this court.
Just to explain, it's the basis on which the Court of Appeal, whilst affirming the district judge's methodology, interfered with her award in the Briggs case, because they said that she impermissibly came below the common law amount for the diffuse knee and elbow injuries. So it was argued, and it is part of the outcome in the Court of Appeal in the Briggs case.
And my Lord, it is also argued for here, and it's not an add-on. Anticipating the court thinking, well, can we go for an adjusted third option but drop the caveat? With respect, that doesn't work, because it just indicates the problem with the third approach, which is that a court is trying to adjust to non-commensurate awards.
I'm afraid I'm finding this counterintuitive and rather difficult to understand. If somebody has whiplash and diffuse knee injuries, how can they end up being awarded less than if they had the diffuse knee injuries alone?
Because Parliament has identified a particular mischief in whiplash injury cases.
Well, I understand that Master Barro's position.
And we say it's the correct position. I can take your Lordship to the explanatory memorandum and the explanatory notes that clearly set out that. And that leads to just the results that my Lord, your Lordship has just identified. It does. It's not a reason to hold against our approach. We say that is the very thing that Parliament has legislated for.
And I understand. The argument is that that's a consequence of the way the legislation is expressed.
It is. I keep referring to the provisions of the Act. Might I ask Lord and my Lady to turn to the Act?
Just before we do that, but the caveat is a necessary part of the approach being put by the Court of Appeal. I don't think we could sensibly eliminate it, could we?
No.
Because it's meeting the argument that Lord President has just put, that it produces, if one isn't careful, the bizarre result, otherwise, that you would be worse off by claiming for whiplash and another injury than if you just claim for that injury alone, which is hard to believe that can be a sensible approach. So the caveat prevents that problem.
The caveat prevents the problem as the Court of Appeal saw it, the majority in the Court of Appeal. But we say that, and the Master of the Rolls said, that's not the problem. That's the mischief that the Act is directed to.
But coming at it from the other side, you then end up with the master of the rolls solution, which is that you can't drop a whiplash claim if you've got another claim and just choose to bring the non-whiplash claim.
Absolutely.
Which he says, well, that looks very odd. In fact, I'm reading between the eyes, but between the lines, but no solution is perfect. But it would surely be a nonsensical solution that we can't require claimants, can we, to drop.
My Lord, there's no requirement that a claimant suffering a whiplash injury brings a whiplash claim. Clearly, that would be, one cannot require a claimant to bring that claim. What the Master of the Rolls is holding, and we say is a correct reading of the Act, is that if a whiplash claim is suffered,
if whiplash is suffered,
if a qualifying whiplash is suffered, then the fact that it is suffered needs to be taken into account when the court is awarding damages. So even if a claimant who has suffered a whiplash injury only brings a claim for the knee injury, the court needs to take into account that a whiplash injury has been suffered, that attracts the tariff amount, and all that will be recoverable for the knee injury is the additionally caused PSLA.
Well, this is very difficult, isn't it? Because you are saying to a claimant says, look, I'm not saying I've suffered a whiplash injury, but I have suffered a knee injury. You're saying to that claimant, you can't put to one side a whiplash injury. Where are we going to get the evidence that they've suffered a whiplash injury if the claimant's not prepared to put it?
That will be an issue that will again come back to the medical reports, but also the claim will need to identify the circumstances in which the knee injury took place.
Surely the claimant isn't required to say all the incidents that have occurred. They're only concerned with the claim that they're actually bringing. The claim they're bringing is for the knee.
The claim may be for the knee, but the circumstances in which the knee injury was suffered will be a matter that the medic would need to consider and the court would consider. And the reason...
The defendant would be the person who raised the whiplash.
It may be if the claimant chooses not to raise it as part of setting out their case. But picking up on Lord Borough's characterisation that this is somewhat bizarre, we say that this is what Parliament intended because it is a targeted attack on what Parliament perceived as the mischief of whiplash claims.
Well, but the logical conclusion is that if even if nobody ever claimed for whiplash again, people wouldn't be able to recover for other injuries because they objectively had in fact suffered whiplash.
That indeed is what the Master of the Rolls said is the correct interpretation of the Act, because otherwise the mischief simply mutates and we move away from whiplash claims in road traffic accidents to knee injuries suffered in road traffic accidents.
It's rather overkill, isn't it? Just assume that the mischief, if one takes even a more extreme view of the purpose of this legislation than was actually held, just say the purpose was to eliminate whiplash claims entirely. Legislation would go even further than that in cutting down claims, even if nobody ever made a whiplash claim ever again.
That's because the focus of the Act is on the circumstances where a whiplash injury has been suffered.
Yeah.
And the tariff is therefore addressing that issue. And if in the background to a claim a whiplash injury has been suffered, we say that that's the only sensible reading and integration between the tariff and the common law damages.
Well, you seem to be saying that the interpretation of the Act does produce absurd consequences, but that's what the Act says.
Well, we don't accept, my lord, that they are absurd.
Well, I'm not sure you've answered why it doesn't seem bizarre for effectively a requirement that a claimant can't, if you like, ignore a whiplash injury that they've suffered. I mean, what I'd be putting to you is it so clear that the legislation does require that? Is there an alternative interpretation that avoids an absurd consequence, is how I'll put it?
Could I ask your lordship and the court to turn to the Act itself?
Yes, that's perhaps a good idea.
And we find that at page 332, and we can explore that, my lord, with respect as we work through that. To explain the colour coding of sidelining, my sidelining is in green, the claimant's in red, and the intervener's in blue. Apologies that it goes awry in some places. And the first example I'm taking the court to is one such example. That's at page 330, the long title of the Act. An Act to make provision about whiplash claims. That my learned friend says, my learned friend Mr. Williams says that that's the starting point but also the finishing point, and therefore that the Act is only making provision for whiplash claims and therefore says nothing about the damages payable for the non-qualifying whiplash injury. However, the Act is, as we'll see, making provision for all PSLA caused by the qualifying whiplash injury, and that necessarily includes any concurrently caused PSLA as found on the facts. So the Act therefore is making provision for concurrently caused PSLA. The issue between us is what provision it makes. So to understand what provision the Act makes, can I ask the court first to turn to section 3.1a, which is at page 332. This section applies in relation to the determination by a court of damages for PSLA in a case where a person suffers a whiplash.
Going back to section 1, can you give an example of what would be accepted in 3? What kind of injury are you talking about there? Well, you can think about it.
My lady, I will. I was trying to think whether there was anything I could draw your ladyship's attention to on the facts of these cases, but I can't. Can I come back to that? Because I don't think it actually affects the issue of principle. What is perhaps more pertinent is not the definition of whiplash injury, but 1.4, because a claimant needs not just to suffer a whiplash injury, but to do so because of driver negligence in certain circumstances. And so we see there accepted the classic example which I referred to earlier, which is where the claimant was using a motorcycle. So the way the section works is that section 3.1 is applying to a case where a whiplash injury is suffered because of driver negligence. We go, as my lady has, back to section 1 to see what that comprises. If there is what we are terming, therefore, a qualifying whiplash injury, we turn to 3.2. The amount of damages payable in respect of the whiplash injury is to be an amount specified in regulations made by the Lord Chancellor. I skimmed over the or injuries taken together because it's not in dispute that if one suffers more than one whiplash injury, one is still looking at the tariff amount. One's looking at the overall duration.
How can you...
Yeah, that, if I may say so, that comment rather brings into prominence the point raised by my lady a moment ago. You know, an injury is accepted under 1.3 if it's a part of or connected to another injury.
Connected in what way?
Yeah.
My Lord, if I may, I will come back to that issue on the facts.
I think
if I can deal
rib fractures. Sorry, rib fractures. Your ribs are fractured. Your ribs go round to your back. We've only got a definition of back that says back. It doesn't say spine. It's the back. The back part of you as opposed to the front part of you or the side part of you. If your ribs are fractured, you are necessarily going to have some soft tissue consequences to that, which may indeed be said to be part of your back, but they are accepted.
Lord, I'm grateful.
A broken rib isn't a whiplash injury, is it?
It's accepted. It's outside the scope of the Act because it is not an injury to the back. It's a fracture to your ribs. But a fracture to your ribs, which necessarily will cause some soft tissue damage to your back.
I see. So this is an example that the injury to the soft tissues of your back, which you suffer when you get a broken rib, would be an injury of soft tissue which is part of or connected to another injury. Yeah. Yes.
Lord, I'm grateful to my learned friend because...
So you're looking for, I mean, that's using connected. Well, in the sense of an organic connection, I think. I mean, the question is, why is a knee injury not connected to whiplash injury?
Because an injury only falls within a subsection under 2 if it's a sprain, strain, tear, etc., to the neck, back or shoulder.
Oh, you mean the second? Well, I don't know, but clearly the
1.1 says it has to fall within subsection 2. Subsection 2 is immediately limiting that injury to a soft tissue, meaning non-fracture, injury to a specific part of your body, namely neck, back or shoulder.
Well, this is probably something for us to pursue with Ms. Hitching in the meantime, but
Sorry,
the injury referred to at the end of A clearly isn't necessarily a whiplash injury, as for example your rib fracture. So I mean, what's going through my mind, and I think possibly my lady's mind, is why does it have to be necessarily connected in the sense in which the soft tissue adjacent to the ribs is connected to the rib fracture? And why would not a knee injury sustained in the same accident as the neck injury be connected to it?
Well, it depends how one uses the word connected. If one uses the word connected in a circumstantial sense, that the knee injury was suffered alongside the whiplash injury. But if I can move on...
Because on that approach, you would, concurrent injuries would fall outside the scope of the legislation altogether. And it would be confined to circumstances where a person only suffered a whiplash injury.
My Lord, if I can simply say that is not a reading that any of the parties before the court are urging on the court. It's because that would lead to the result that not all of the PSLA suffered as a result of the qualifying whiplash fell within the scope of the Act. And with respect, we do say that would be an absurd result, and that is not a result that any of us are urging on the court. So the tariff does compensate for all the PSLA suffered by the qualifying whiplash injury. The only issue is how does that impact PSLA caused by the non-whiplash injury? And if I can turn to 3.3.
I mean, 1 is only really concerned with defining the whiplash injury.
It is.
It's not saying anything about which other injuries you may or may not suffer that are not called whiplash injuries.
Correct.
It's just a definition of what the Act means by whiplash injury.
It's the starting point.
Yeah.
We need to move on to
but it doesn't
3.3.
It doesn't define it by referring to the physical effect. That is why it's called whiplash, which is what happens to the spine when somebody drives into the back of your car, because I don't think it says negligence of a car driving into the back of your car. So you could have a front-on collision which doesn't result in the spine sort of ricocheting in the way that's traditionally regarded as causing whiplash. It's why it's called whiplash, because of the comparison between what happens to the spine and giving rise to an injury of soft tissue. And then one would get into a debate which is whether the term whiplash injury of itself constrains what kind of tears and sprains and ruptures fall within the definition of a whiplash injury.
It's not. The Act has not, it's common ground, the Act has not adopted that approach to the defining of whiplash injury. It's adopted the approach of defining the medical symptoms as we see set out at section 1.1, but that doesn't impact the issue that's before the court today. We have to move to section 3.3 to see what the Act provides in relation to qualifying whiplash injuries. And that says, highlighting if the claimant suffers, the amount of damages is to be. So the first thing is, it's still damages. There is no substitution of a statutory award for damages. It is damages. And it sets out that it is to be an amount specified in regulations. So that deals respectfully with my Lord Reed's point. Is there some PSLA caused by the whiplash injury that falls outside the Act? No. All the PSLA caused by that falls to be compensated by the tariff. If we move through to section 3.8, this is the nub of the point between the parties. Nothing in this section prevents a court, in a case where a person suffers an injury or injuries in addition to what we're calling the qualifying whiplash injury, nothing prevents the court awarding an amount of damages for PSLA that reflects the combined effect of the person's injuries. What does that mean is the heart of the dispute between us. We say that what that means is a court can award an overall amount of damages that compensates for the whiplash and for the non-whiplash injury, but it does not, because of the phrase in parentheses, permit the court to award more by way of damages for the whiplash injury than the tariff amount. The tariff amount compensates for all PSLA caused by the qualifying whiplash injury, which necessarily includes the concurrently caused PSLA. So the court, in ordering an overall award, takes the tariff and adds on to it damages for any additional PSLA caused solely by the non-qualifying whiplash injury. Any more would be to permit common law damages by way of a top-up to the tariff sum.
31B is, I think, helpful in trying to work out what 1BA means, because when it refers to the whiplash injuries suffered on that occasion, an implication must be that you could suffer more than one whiplash injury on the same occasion, but they would not be connected, otherwise they would be excluded from the operation of Section 3.
With respect, we see that more directed, and I think all the parties do, more directed to the fact that if more than one whiplash injury was suffered on one occasion, one is looking at a single tariff amount.
Yes, it was that reference to more than one whiplash injury being suffered that made me think they must be talking about whiplash injuries as a broader class of injury than what's traditionally thought of as a whiplash injury, which is what you suffer when you jerk forward because somebody's shunted into the back of you. So if whiplash injury actually means any soft tissue injury to your back or your shoulder,
neck, back or shoulder, as per the definition in section
then
1.
it is actually much broader than what the medical profession would think of as being a whiplash injury.
If I can put it this way, it's certainly possible for there to be more than one whiplash injury suffered in a single accident, which is why Section 3 is framed as it is.
Yes, it's a slightly different point the lady is making. I mean, for example, say the car stopped suddenly and a parcel came off the back shelf and hit the back of your neck. That could be a whiplash injury by the look of things in terms of this legislation.
That there are certainly arguments that falls within the definition of Section 1. I don't want to preempt arguments in cases that might be before the court. Can I, having taken the court through those sections...
The regulation-making power, is that only to make... It's only to cover whiplash injury or the minor psychological injury? Because when I first read Section 3.8 and the words in parentheses, subject to limits imposed by the regulations, I wondered whether that was anticipating some additional limits being imposed by the regulations on combined effect of whiplash and non-whiplash injuries, which in fact was not a power that has been used in the making of these regulations.
No, that phrase is directed towards the limits that one can already see under that section. And if I can ask your ladyship to turn to the regulations, which appear at page 350 of the bundle, we can see that at Regulation 2, referring back to being a regulation made under the Act, that specifies the total amount for damages for PSLA is the tariff amount, and then we see the tariff amount set out over the next page. So we say the phrase "is to be" in Section 3 is sufficient, but the draftsman of the regulations, belt and braces, has inserted the word total. So the total amount of damages for whiplash PSLA is the tariff amount. So no more, we say, can be awarded for any PSLA resulting from a qualifying whiplash injury than the tariff amount. If I can ask the court to turn next to the external aids to interpretation, and I've rather passed over the principles of statutory interpretation. They're is no dispute between the parties on the principles to be applied. I've set them out, and I'm also mindful that the members of this court have each been involved in the leading judgments setting those principles out. External aids to interpretation that it's agreed the court can look at here are the explanatory notes and the explanatory memorandum, to which I'll take the court next. It's not agreed that the court will be assisted by, or indeed it's admissible to put before the court any further material. My learned friend Mr. Williams has made reference to some extracts from Hansard. We say they are inadmissible, and indeed, as I was going to say, as does he, and I'm grateful for that acknowledgement. I therefore won't go to those passages. His instructing solicitor, Mr. Signer, has also put in a witness statement that refers to an article or a blog as to what may or may not be the practical effect years down the line of the Act, and some crew registration data with respect. That's also inadmissible, in the same way as a court is not assisted interpreting a contract to see what the parties have done. They may have based their conduct on a mistaken interpretation, nor is this court going to be assisted interpreting the Act by looking at that data. So the only external aids to interpretation we say are the explanatory notes, and we can see those at page 979.
Could you just give me the page references for the material that we're not going to be looking at? That is, that was. I'm not sure.
All of it.
I'm not sure. I'm not even sure I've even seen them.
That got me thinking. The Hansard references. Perhaps I can leave my learned friend to identify which of his Hansard pages he doesn't want to refer to.
It was the last reference.
This, my lord, yes. The Signer,
the blog or something.
Mr. Signer's blog. That's page 1570, I believe. 1574.
I've got a list of this. The article that Mr. Signer cites is 1574. 1568 has got the statistics from the Compensation Recovery Unit, which shows there's been a very substantial fall in motor claims. And 1578, there's some information that my learned friend solicitor, I think, added to the bundle, which is the report from the Official Injuries Claim Service itself.
Thank you.
Without undermining my submission that it's inadmissible, it also doesn't show what my learned friend thinks it shows, and I really don't want to trouble the court to go through crew registrations to show that there hasn't actually been the drop he perceives. And in relation to the material that we put before the court, it was purely there on the permission to appeal application to show that these test cases raise points of public interest. If I can ask the court, therefore, to turn to the explanatory notes to the Act, which are at page 979 and following. The key section is at page 983, and I would commend paragraphs 3 to 7 to the court in their entirety, so I'm not thought to be selecting certain sentences. But we can see there in summary that Parliament's concern was not limited to tackling fraudulent or exaggerated claims. The mischief Parliament perceives and is tackling by the Act is more extensive, that the number of RTA-related personal injury claims is too great, and that the level of damages for whiplash claims is not, in Parliament's view, proportionate. So Parliament intends to address the cost of that, which is passed on to ordinary motorists through premiums. The overall aim being to reduce insurance premiums by reducing the level of awards to a level that Parliament considers proportionate. And turning to the explanatory memorandum to the regulations at page 999, we see that aim expanded on at page 1000 refers to the legislative context, which I've taken the court to. And then the policy background at page 1001, what is being done and why. Again, commend the entirety of that page, sections 7.1 to 7.8 to the court. In summary, we again, at 7.1 to 4, see a clear statement of the mischief to be tackled, which is wider than false claims. 7.5 goes on to explain that there is, of course, another cost associated with claims, which was also being passed on to defendant insurers and ultimately to all motor insurance premium payers, and that was the legal costs. Parliament considered all qualifying whiplash claims under 2 years to be minor, but none of them were falling within the small claims track. Because of the amounts that we've seen were being awarded under JC guidelines, even in the most minor cases, they were attracting awards for damages above the £1,000 limit that the personal element of a claim needed to be for the claim to be within the small claims track. The significance of that is within the small claims track, the parties bear their own costs. Outside, legal costs are recoverable in addition to damages, which obviously increases the overall level of the awards and is ultimately passed on to premium payers. And we can see that at paragraph 7.5, that has been addressed by raising the limit in the small claims track on the personal injury element from 1,000 to 5,000, which is obviously above the level of the tariff set for the qualifying whiplash injuries that we've seen. And at 7.6, we see reference to the official injury claim portal, which enables such claims to proceed online in their early stages through assisted settlement discussions, if I can put it that way.
The official injury claim portal, that pre-existed these whiplash regulations, or was that...
My lady, no. They're all brought into force on the same date.
Well, that was why I was puzzled when you said earlier a couple of times that the practicalities of pursuing these claims should not influence how we interpret the legislation. Because if, as you're now suggesting, this introduction of the tariff was part of an overall package which was aimed at reducing the costs of pursuing these claims, bringing them into the small claims track, helping them to settle rather than fight, then doesn't that influence how we interpret the specific provisions as to whether that a particular interpretation makes it less likely that they'll settle, more likely that they will be expensive and that those costs will be borne by the claimant and may then override the value of the claim?
My lady, it certainly does influence it, but it doesn't drive the interpretation that one should go towards either of the other two options.
Well, I'm not quite sure of... Well, yes, okay.
Because the context which your ladyship has rightly set out supports our interpretation that only the tariff amount and not more than the tariff amount should be awarded for concurrently caused PSLA. Because if common law damages are awarded in addition, that will increase the level of the award. It will push such claims outside the portal and outside the small claims track, which will drive the opposite to what Parliament was seeking to achieve. The practicality point that your ladyship rightly raised, which is, does this require the medics to tighten up their reports? If it does, that can be done within the portal, within the existing regime. So that doesn't drive an interpretation other than our interpretation. And given all these matters came into effect on the first day, on the same date, they're all part of a single scheme designed to keep the level of whiplash injuries down. And down, not just in terms of a reduced amount, but down to the level of the tariff. And I stress that because what this court is seeking to find is the interpretation that achieves Parliament's precise aim, which was not just to reduce damages for whiplash injuries, but to reduce them to the level of the tariff. And only option 1 actually achieves that. The other matter that will be relevant in interpreting the Act is the common law background. That again is largely, as one would be expected, agreed between us. The principles of compensation are long established, and I don't propose to trouble the court by going through those. The one topic that appears to be, that is between us, certainly between my learned friend Mr. Weir and me, is the issue of double recovery as it is understood at common law. So that's the topic I propose to concentrate on in oral submissions, whilst not departing from anything that I've put in writing. Before diving into that, because it will be at some length, I do want to say that there is an element of it doesn't matter ultimately whether the court is with me or Mr. Weir on the common law background, because ultimately the common law background informs the understanding of what Parliament may have been doing, and bearing in mind the presumptions in Lasho, the court will be presuming that Parliament has been is apprised of the common law background and is not legislating further than necessary. However, we each say that the wording of the Act is clear and points towards the interpretation. So I will take the court through the common law background, but ultimately this comes back to the wording that I've taken the court to, and in particular the phrase "is to be." Four aspects of the topic of double recovery. First, what is the principle against double recovery? Secondly, does that apply only, as my learned friend Mr. Weir argues, in the context of judicially assessed damages? So no relevance here. Thirdly, is the principle qualified, as he suggests, because sometimes betterment is unavoidable and is compensated? And fourth, if it is qualified here, are we looking at a betterment scenario or anything analogous? First, what is the principle against double recovery? Well, we say, and I deal with that in my written case at paragraph 35, page 99, it's not really a separate principle at all, just an aspect of the long-established aim of compensation in tort, which is to reverse the effects of all legally recoverable loss, which, unpacking it, means a claimant is entitled to have such losses reversed, but not to make gains. That would be overcompensation, or we're using the term double recovery. And that we obviously take from the well-established case law, and in particular the Livingston case. How does the court get at the sum of money which will fully compensate? Well, compensation should be full, not over or under compensation, but how does a court put a number on that full compensation? Then, because the notion of full compensation is linked to, but conceptually distinct from, the issue of valuation. Well, different fields of law throw up different challenges, but in the personal injury context, if we turn to, it's so familiar, I don't need to ask the court to turn to it, the principle in Highland Rankin, the court is trying to find the figure that is fair, just and reasonable in the circumstances. In fact, if I ask the court to turn to it's page 1377, paragraph 23. There is no simple formula for converting the PSLA into monetary terms. Any process of conversion must be essentially artificial. Reading over to page 1378C, the assessment requires the court judge to make a value judgment and then refers to the importance of consistency. So the court is also aiming to find a global sum, as we know, where there is more than one injury, and that's Sadler. If we turn to the judgment in Sadler at page 831, we can see there set out the familiar approach, which is to consider the various injuries, then to stand back and look at what will be a global aggregate figure. And we see that also in the same judgment going back to page 827. And here we see reference to the phrase combined effect, which we also saw in section 3H.
But there's no reason really why they couldn't have gone the other way and gone for an option one, even though you were dealing with two sets of common law damages.
Indeed.
So they could have said, no, the way to do this is work out what the person gets for their scarring on their leg.
And build up.
And then that's what they get, unless they can show that their other injuries have added more non-concurrent pain.
Indeed. Your Ladyship's one step ahead, because that's what happens in Duro. So the Sadler approach isn't the only approach that can be taken at common law. It's one approach that is taken. It's the add two things together, recognise there's an overlap, stand back, and try and adjust in order to remove the overlap. The other approach, which is perfectly permissible, we see in Duro, which is just the approach your Ladyship has outlined. You start with one injury, and then you build up to add on any PSLA solely caused by that other injury. Both approaches, if done properly and if done with precision, should result in the same number. And that really brings me back to the response I gave to my Lord Burrows earlier, which is there should be precision even at common law. And it doesn't matter whether one adopts the Sadler step back and adjust or the Duro build-up approach. One is aiming for a final award that eliminates any overlap of compensation. I took the court to paragraph 34 in order to see the phrase combined effect in context, because what combined effect, which is a phrase which appears in section 3.8, is referring to is just that issue. When one is standing back, it may be that there is what is referred to as synergistic loss. So the two injuries together create extra loss than they would each create on their own. That needs to be compensated. Or it may be that their combined effect is purely the concurrent loss that we are talking about in this case, and then there needs to be a downward adjustment. But the alternative approach, which the court adopted in Duro, was just the approach that Lady Rose mentioned, which is one starts with one and one builds up. So what we're suggesting by option one is not unknown at common law. It's just the approach that the courts have been used to taking under Duro. But we say here it's the only approach that could be taken, because otherwise one is comparing non-commensurate bases of award.
Could you just give me the reference in Duro that you're relying on?
Yes, my lord. It is page... I believe it's 829, but I don't want to turn the wrong... For 373, I'm grateful to my learned friend. He shouldn't have to step in as my absent junior, but I'm grateful to him. So at 373, reading partway down from the paragraph beginning help, it may be necessary, if it be possible, to select what may be the most serious head of injury to see if a comparable award can be found in relation to that, and if so, to build on it, to allow for the other heads of injury which have been sustained by the plaintiff in the instant case. Now here, we are not saying that the tariff injury would necessarily be the most serious, but one needs to start with that because the Act dictates that only the tariff sum can be awarded for that injury. Therefore, that's the one starts with, and then one builds up, adds on any additional PSLA from there. So the common law background can give the court assurance that the approach of the Master of the Rolls is not a novel one at common law. The reason that the court has to choose this Duro build-up approach rather than the Sadler approach is because it's the only approach that is guaranteed to respect the tariff limits.
But it may be that the reason Sadler has been preeminent, if it has, is because it's proved to be an easier way of dealing with these matters.
My lord, it may be, but I wouldn't make that concession, and there's certainly no submission to that effect before the court, and it would be rather concerning if there were, because what the court is aiming for is what is fair, reasonable and just compensation. And that should not enable a method which is a bit hit and miss to be adopted. So whether it's a Sadler approach or it's a Duro approach, there should be the medical evidence before the court that enables a court properly to identify the overlap and to value it.
But Sadler is the generally applied approach, is it? The judge said traditional approach, is that correct?
It's the traditional approach. Yes, it's the approach that the courts usually use, but it's not that that is, as a matter of principle, the correct approach, and the courts can use Duro. Turning to the next point of difference between myself and my learned friend Mr. Weir, does that principle against double recovery only apply where we are talking about judicially assessed damages? We say no, because that will be to conflate the issue of what loss exists with valuation. Now, the case law on double recovery in the personal injury field has necessarily developed in the context of judicially assessed damages, but that doesn't mean that the principle is limited to that context. An example of where it applies outside that is where the parties contractually agree a rate for liquidated damages, that was a Freudian slip, in the event of breach. They may well be limited, they may well not, as assessed by a judge after the event, fully compensate. But the new law, which is obviously most recently summarised in the Armstead case, where my Lord Burrows gave the joint leading judgment and my learned friend Mr. Williams successfully appeared, is that the clause does not need to be even a genuine pre-estimate of loss to be upheld. If the clause is upheld, then a claimant can only recover liquidated damages, cannot ask the court to top up to compensate for the real loss suffered. A claimant is treated as having been fully compensated. The analogy is not direct, I accept that, because the statutory tariff is not liquidated damages, it's a unique regime. But there is some analogy that the court may draw, because it is a rate set in advance with the aim of compensating the PSLA caused by a qualifying whiplash injury, and doing so exclusively, being the exclusive remedy. So we say liquidated damages clauses are an example of the rule against double recovery applying, even where a court is not awarding damages which it values as fair, reasonable and just. Even if my learned friend were right that the principle of double recovery only applies to judicially assessed damages, with respect, that doesn't help him, because common law damages are being awarded for the non-tariff injury. And at least to that extent, the principle of double recovery applies. So a court valuing the non-tariff injury would need to factor in that concurrently caused loss had already been or was being compensated by the tariff. My learned friend's response to that appears to be that the tariff sum shouldn't be taken into account because of the case law on unavoidable betterment. And that's our next point of difference. We say that that simply misunderstands what the cases before the court on unavoidable betterment are dealing with. If we turn first to the case of Lagden and O'Connor, and that's at page 419. One can see reference at the bottom of page 420, paragraph 30, to the context where a claimant is under an obligation to mitigate their loss. What the court is searching for is what is the recoverable loss. If steps are taken successfully to mitigate the underlying loss, then that loss that might, but for those steps, have been suffered, but which has been avoided, obviously cannot be claimed for. At paragraph 30, the court is considering a further question, namely whether there can be offset against loss that has been suffered any gains made as a result of mitigation. Is the court compensating for the net losses once you set off that gain, or ignoring that gain? And the answer in the context where the incidental gain is made because of mitigation is clear. It's not brought into account. And that's page 421C. It is not open to the wrongdoer to require the injured party to bear any part of the cost of obtaining such indemnification for his loss as will place him in the same position as he was before the accident.
Could you give me the reference to that again, sorry?
Page 421C, my lord.
Thank you.
So that's the situation of mitigation. A slightly different scenario is that was the Lagden case, is the Longden case, which is at page 467. And the reference where I'm going to read from, my lord, is page 477D. Everyone is agreed that the plaintiff cannot recover any more than his net loss of pension. The argument is directed only to the question how that net loss is to be calculated. And this is not the mitigation scenario. This is the scenario where monies have been received because of the wrong that the claimant suffered. And what the court is concerned to do is to look at the precise benefit received to see whether that is of a type that should or should not be taken into account. And we can see at 477E, the court is looking at the different approach that it takes to different types of receipts. I skim through that because that is of no direct bearing in this case. We get to page 484D. The principle, reading just below D, the principle is that the plaintiff must be compensated, but no more than compensated for his loss. The concern of the court is to see that the victim is properly compensated. There must, of course, be no element of double recovery for the same tort.
Sorry, where are you reading?
This is from 484, my lady, D through to E. What the court is looking at is Longden, is whether sums received because of the wrong should be taken into account to lead to a net loss. Once the court has identified whether they should or shouldn't, the net loss is only compensated once. So, properly understood, betterment is not an example of the principle of double recovery being qualified, or an instance where double recovery is permitted. It's addressing the prior question of what is or isn't taken into account and identifying the net loss that the court is compensating. Once that net loss has been identified, the court only compensates it once. So turning to the fourth point of difference between us, the facts of these cases, with respect to my learned friend, don't help him. The tariff sum is not a benefit obtained by a claimant suffering a non-whiplash injury and seeking to mitigate the loss resulting for it. So it's not an incidental benefit of mitigation, which is the Lagden scenario, nor is it a Longden scenario. The tariff sum is not an incidental benefit resulting from the claimant suffering the concurrently caused loss. It is damages for that loss. And for a court to ignore that such loss has been compensated would lead to the double recovery that Longden says is impermissible. So we're simply not in a betterment or mitigation scenario. Even if the principle of double recovery were qualified, as my learned friend suggests, such qualification simply does not apply here. And lastly, even if he were correct, as I said in opening, that takes us to the wording of the Act. So turning lastly to that wording and drawing all the above submissions together, we say that the right to damages for PSLA caused by a qualifying whiplash injury remains. but the value of those damages is now as set by the Lord Chancellor in regulations. There is no room for judicially assessed damages, and there is no room for a top-up to those. The phrase "is to be" makes clear that only the tariff award can be awarded for the qualifying whiplash injury, and that necessarily includes within it any PSLA which is concurrently caused by the non-whiplash injury. Section 3.8 and the reference...
It does say 3.2 and throughout, in respect of the whiplash injury.
It does, my Lord.
So it's to emphasise "is to be" would seem to me to be slightly disingenuous when one's got the phrase "in respect of the whiplash injury."
Lord, by emphasising "is to be," we're not ignoring the remainder of the phrase. It's if you like a Venn diagram, a very simplistic Venn diagram, that all the PSLA caused by the whiplash injury is to be compensated by the tariff. One then has another circle which overlaps that. And the issue is, what can one do with the point of intersection? And we say the only permissible option under the Act is that it is compensated solely by the tariff, because that is the only interpretation that reflects not just the wording that is to be, but the whole phrase as my Lord Burrows read it out. My learned friends rely on the wording of section 3.8, and they say that that doesn't just permit, but indeed mandates the court to order both tariff sum and common law damages as damages for the concurrently caused loss. We say it does no such thing. If it's a reference back to Sadler, then combined effect in Sadler, as we have seen, simply means that the court needs to order an overall sum which compensates all PSLA suffered once. Sadler, indeed, is the opposite of what my learned friends are urging as their preferred option, because it doesn't permit double recovery. So section 3.8 is making clear that a court can award an overall sum, but that's subject to the tariff limits, and only the tariff applies to the PSLA caused by the whiplash injury. My learned friend Mr. Weir says, well, that's trite. If that's all section 3.8 is meaning, it really doesn't need to say that. We don't agree. This is new legislation, and for an act in the context of introducing this novel regime to emphasise that the overall award can comprise the tariff and common law damages is not trite. But we say it goes no further than that, and it is not a platform for the argument that more than the tariff sum can be awarded. Certainly, it is no platform for arguing that more can be awarded and double recovery is positively permissible. And more than permissible is mandated in every case, because that would totally undermine, learned friends' preferred option, totally undermines the intent of Parliament, because in every case where there is concurrently caused PSLA, more than the tariff sum will be awarded. So taking the appeal and the cross appeal in turn, the first issue before the court, which arises on the cross appeal, is whether the Act permits and requires a court to award double compensation for concurrently caused PSLA. For the reasons I've taken the court to. We say clearly not. There is no wording to that effect. That is not the meaning of section 3H, nor can it be implied from the remainder of the provisions or the Act's preface, given that would be a radical departure from established common law principles to permit double recovery. More than implication would be required. And there is in any event clear wording to the contrary as identified by the Master of the Rolls. What would be unacceptable at common law, 2 awards of damages for concurrently caused PSLA, is not somehow now acceptable and indeed required by the Act. Stepping back as a common sense check, Parliament has legislated to reduce the damages for PSLA caused by whiplash, not just to some degree, but to the level of the tariff. And it certainly hasn't legislated to provide a tariff sum in addition to common law damages for such PSLA. No judge below has been with the claimants or interveners in this case. We say rightly so. That takes us to the second issue. If double recovery is impermissible and option 2 is therefore incorrect, is option 1 or option 3 the correct interpretation of the Act? Option 3, that of the majority, does attempt to deal with the double recovery, but as we've seen, the method used to address it doesn't remove it, but builds it in, both by the reference back to common law levels of award for overall damages, but also by the caveat. The only interpretation which upholds Parliament's clear intent to reduce damages to the level of the tariff is therefore option 1. And I respectfully invite the court to answer the question before it, as I've set out at paragraph 74, to allow the appeal and dismiss the cross appeal. As these cases are test cases, courts at first instance may well be assisted not just by that answer, but by some practical guidance. And therefore, at paragraph 75, I've set out some short practical guidance. Mathematically, as my Lady Rose pointed out, it doesn't matter whether one starts with the tariff and adds common law damages for the PSLA solely caused, or starts with the common law damages and adds the tariff to it. And we're not saying that the tariff is, the whiplash is the major injury. But I've set out the practical guidance to take the tariff sum first, because that reinforces to judges at first instance the importance of ensuring no double recovery for concurrently caused PSLA.
Thank you very much, Ms. Hitching. Mr. Willie.
May it please your lordships, your ladyship. And if I can just start with a high-level examination of the consequences of the learned friend's case before coming in a little more detail to the statute. And I'll take Mr. Rabot's case as the example. Mr. Rabot suffered an injury to both his knees. Having considered the Judicial College guidelines, the district judge determined that common law, that injury alone in isolation would merit an award of £2,500, and no one has challenged the correctness of her assessment in that respect, applying common law principles to the injury which is to be valued at common law. Yet the defendant's case is that the effect of the Civil Liability Act is that Mr. Rabot's compensation, not just for his knee injury, but for his neck injury as well, should in fact be £1,855. So about 25% less than he'd received at common law just for the knee injury. And that award, they include within it an element of £465, which they say would be attributed to the knee injury. So in other words, they say the Civil Liability Act has radically reduced what Mr. Rabot gets for his knee injury. But that's
can I just ask you,
yes.
Where is that laid out? Sorry, those figures.
Those figures, if you go to the, I took them from the judgment of the district judge. The district judge's assessment of the, which is at page 189 is her conclusion, my lord.
Yes.
And it's paragraph, I think it's paragraph 40 where she identifies what she would have allowed for the the knee injuries in isolation.
It's the 465 figure.
The 465 figure, your lordship will find if you go backwards to page 182, which is the first page of the judgment.
Yeah.
And you'll find it at paragraph 2, the final sentence of paragraph 2, where the district judge summarises the competing positions.
Yes, the offer's being made. It's not as if they are the carefully worked, calibrated approach, is it? I mean, what I'm driving at, my understanding was that if we applied the approach that the Master of Rolls was suggesting, we haven't got any figures at the moment that would correlate to that approach. Are you suggesting that these figures are that?
Well, what certainly I think it's common ground now that if the court allows the appeal and dismisses the cross appeal, that there should be a remission. But what I'm saying is that hitherto the case has been put on the basis that the total valuation which the court below should come to, and I don't understand there to be any ever having been any residing from this. There certainly wasn't in the Court of Appeal. That the total sum payable to Mr. Rabot should be the 1,855, which I've identified. And of that, the 1,390 for the tariff injury is common ground. That's common ground. That's what the tariff leads to. So 465 is what they contend for the other element. But for present purposes, what I was intending to stress is a high-level observation, and it's a point that's already been put to my learned friend.
So if it was option 1, it would be 1390, which is the tariff. And then it would be whatever the judge thinks has been an injury, pain and suffering, loss of amenity, which is exclusively referable to the knee problem.
Correct, my lady, yes.
And you're saying that figure is 465 as far as the parties are concerned?
That's certainly how it's been put hitherto. And what I suggest is, and I appreciate I'm just making some high-level points in order to open, is it does expose the starkness of the defendant's contention, which is that, as I think I was beginning to say, an act which in our submission is exclusively addressed to damages in respect of whiplash injury, has, by a side wind, as it were, or a side blow, reduced the sum payable for a completely different sort of injury, simply because of the happenstances suffered at the same time as a soft tissue injury to the back, neck or shoulder. And in our submission, that is as a starting point, it is a troubling proposition, and that's really what Lord Justice Stuart Smith said in his assenting judge, his concurring judgment in the Court of Appeal. He makes the point that the Master of the Rolls accepts that the legislation doesn't impact on non-whiplash injuries, but he nevertheless goes on to find that he's inexorably led to the conclusion that when the non-whiplash injury is suffered on the same occasion of a whiplash injury, it radically reduces the common law compensation payable for it. And in our submission, it will be that conclusion is wrong, because in statutory language, which my learned friend consistently avoided until my Lord Burrows picked up on it right at the end of her speech, is the only thing the Act controls is the compensation which is payable in respect of the whiplash injury. Which, as we have seen, is an injury of the soft tissue in the neck, back or shoulder. The Act doesn't address any other sort of injury. And at the risk of making a point which is blindingly obvious, insofar as there is loss, whether it be pain, suffering or loss of amenity, which has a concurrent cause attributable both to the whiplash injury and to the non-whiplash injury, then insofar as it is attributable to the non-whiplash injury, then the parliamentary prescription of the damages recoverable in respect of the whiplash injury is simply neither here nor there. because insofar as symptoms are attributable, or inconveniences or losses of immunity are attributable also to another injury, Parliament leaves the assessment of compensation for that injury completely untouched. And what my learned friend's submission really entails, as I think it's the language we use in our written case, is a sort of statutory appropriation of the whole of the common symptoms, such as they may be, to the whiplash injury, when that simply, in our respectful submission, is not the language of the statute. The language of the statute is addressed to damages in respect of the whiplash injury, not in respect of the other injury. And even if we're wrong about the plain words of the statute, on any view we submit, if Parliament in a statute which we say is clearly and overwhelmingly directed at whiplash injuries wants to influence the compensation and radically reduce the compensation payable for a different sort of injury, then it needs to be spelled out much more clearly than this legislation does it for that to be effective. So when both the defendants and, with respect, the dissentient master of the rolls and the lower court say it follows inexorably from their analysis the Act has had a radical impact on the valuation of other sorts of injury, if by happenstance they're suffered at the same time, we say that it actually exposes the fallacy of their points, because that's not what the legislation anywhere indicates. There is no equivalent indication in any of the travaux préparatoires. And clearly, if that had been the intention of the legislation, it wouldn't have been difficult to spell it out. But that hasn't been done. And so when my learned friend says, as one of her sort of cadences to her submissions, that only her option one achieves the statutory purpose of reducing damages for the whiplash injury to the tariff, with respect to her, she's wrong about that, because on our analysis, the damages in respect of the whiplash injury are still reduced to the tariff. My learned friend's, with respect, misplaced comment in saying that they're not, in fact, exposes, we submit, the misconception in her argument, because she treats the Act as regulating damages in claims which include a claim for whiplash injuries or language of that sort. But as we have seen, that is not the statutory language. It limits the damages payable in respect of the whiplash injury and not the damages which remain accessible at common law in respect of any other injury that would be suffered at the same time and which may or may not cause some common loss. But there is no sort of statutory hierarchy where, insofar as there is common loss, it is all piled onto the whiplash injury in order to save the defendant a bit more money. There is nothing in the Act to show that it operates in that way. My lords, my lady, that's not the only difficulty in their position. Again, still by way of some high-level starting points. Because again, as my learned friend herself emphasised, for example, taking you to the explanatory memorandum at page 1001, the Act was part of a package of reforms which also includes a streamlined claims process, which, at least in theory, is said in those explanatory notes to be accessible by litigants in person. Now, to value their whiplash injury, you can see that it is indeed accessible by litigants in person, because the only thing the claimant needs to know is how long does the medical expert prognosticate the injury will last, and that locates it in the tariff. But insofar as they have other claims, the historical view has always been, and it must be said, the view that the official guide to the official injury claims service itself takes is claimants just need to look at the Judicial College guidelines. And the Judicial College guidelines, for what it's worth, are actually appended as part of the official injury compensation services guide, which is made available for litigants in person. But my learned friend's case, as the court has probably already seen, makes the Judicial College guidelines completely useless. If a future Mr. Rabot consults the Judicial College guidelines, he's not going to see any indication that his knee injury is only worth £460, or Mr. Briggs, where the corresponding figure that the defendant threw out in front of the district judge was £700. The litigant in person is going to see Judicial College guidelines which indicate a completely different sort of award. The short-term knee injury as it happens, which, because I've been dealing with Mr Rabot's case, that indicates an award of £2,250. And it's that which led to the district judge to allow £2,500 because it was an injury to both knees, not one knee. And the bundle reference for the relevant Judicial College guideline is page 367. And indeed, even to us, and I have the temerity to speak on behalf of my learned friend Mr Weir as well as myself, as legal professionals with the privilege of appearing in the Supreme Court of the United Kingdom, the provenance of the defendant's attribution of £460 of compensation to Mr Rabot's knee injuries is completely obscure. It's never been explained. We don't understand it. It's doubtless for that reason my learned friend new to the case my learned friend Miss Hitching, new to the case, has for the first time in this court said, well, actually, if the appeal's allowed, it would need a remission, because I doubt that she can explain it either. But it does throw up another practical problem. The defendant's approach subverts the whole scheme of a simple claims process, backed up by a simple and fixed cost medical report, in which a claimant can look at the tariff for the whiplash, can look at the guidelines for the non-whiplash, and at least come to a rough valuation without needing to put matters up to a judge. And of course, as always, it's so easy for members of the judiciary and us at the bar to forget that it's only the cases that have failed other cases to go to court. What these processes are all actually meant to do is to facilitate settlement. How does one settle, I ask rhetorically, on the basis of an argument by the defendants that make the Judicial College guidelines completely lacking in any assistance? In fact, they're the contrary of offering assistance. They offer the contrary. They confuse, because a claimant looks at them and thinks, oh, my knee injury is worth £2,250, only to see the defendant insurer say, oh, no, it's not, it's actually £465. So there are other practical difficulties as well, which I will come to, but they've been to a considerable extent presaged by the questions asked of my learned friend by my Lord Burrows. But we will say that you can't dissociate practical considerations from the process of interpretation in the way that my learned friend initially contended, essentially for the points already put to her by my lady. The defendant's own case is that this is a single coherent scheme, and just the reference to that is their case at paragraph 40, which includes the aim of accessible and cheap dispute determination. That's their case at paragraph 48. But how we ask rhetorically, do you get that when you need such a painstakingly nice approach to damages as follows, if I can adopt the adverb that the Master of the Rolls used in a different context, inexorably from the defendant's case? Nice counterfactual questions. Well, let me go back to the example put by my Lord the President about the amateur footballer. If I hadn't suffered the knee injury on top of my whiplash injury, might I still have been able to play football? Would I have been able to do it, but it would have been less comfortable? Or perhaps I'd have kicked a ball around, in the back garden with my son after school or my daughter after school, but I probably wouldn't have gone to the much more strenuous five-a-side game in the local park that I generally do on a Saturday morning. One mounts counterfactual upon counterfactual. You create perverse incentives, because again, I think a point my Lord the President didn't quite put it out, or spell it out, but I surmise it may have been, with respect, playing on his thoughts, that you come to the perverse situation where it is in the defendant's interest to emphasise the seriousness of the whiplash injury, and of course the claimant, if they're well advised, not suggesting they'd be dishonest, but the most they can honestly attribute to the non-whiplash injury will be attributed to it. All in the context of a forum where the ability to test evidence is, of course, deliberately kept to an absolute minimum. And again, it perhaps is just worth bearing in mind. The cases before your Lordships and your Ladyship are atypical in one sense in that there's reserved judgments, careful reserved judgments by the district judge. That's obviously a product of the law being uncertain. These cases are actually intended to be disposed of, if possible, on paper There's no expectation there would necessarily be a hearing at all. If there are hearings, I think the debate in the Court of Appeal, it was suggested that the hearing might typically be listed for about 45 minutes, including judgment. No oral evidence. There is oral evidence from medical experts is expressly forbidden. There is a facility for claimants to give evidence, but it's not a facility, as I understand it, which is commonly invoked, and certainly in neither of these two cases, notwithstanding that even before the district judge, they were clearly being taken relatively seriously, argued by counsel, reserved judgments. In neither of these cases was there oral evidence from the claimants themselves. So the whole framework is of accessible and cheap dispute resolution, where my learned friend has rightly said legal costs aren't recoverable. You do get the cost of the medical report, but the medical report, that is strictly controlled under the practice direction. I'll give you the reference after the short adjournment, but in general, medical reports under this regime, the recoverable cost is fixed at £180. And what is completely typical is the medical report in Mr. Briggs's case does disclose that the entirety of the interview, history taking and examination with the expert, it took 15 minutes. Which is not surprising if a medical expert only gets £180, and that has to include writing the report after the interview and examination. Now, on my learned friend's analysis, the history taking, in fact, in these sorts of cases needs to be a lot more detailed than it is to be in a normal common law case, where you can have the sort of broad brush approach of a Sadler type question, because it doesn't normally matter, firstly, whether you attribute a particular loss of immunity to injury A or injury B. And you don't have to explore a counterfactual. If you have a case of a let's say the national footballer, but he hasn't suffered a soft tissue injury to his neck, he suffered it to his ankle, and so he can't play. He can't play football. But he's also got a sort of strained hip or something like that as well. I mean, you don't have to, in those questions, ask, well, which of those two things caused you not to be able to play football? And would you have been able to play football if perhaps you'd only had one of them? I mean, these counterfactuals are unique to this area and my learned friend's analysis of this area.
Can I just make sure I understand that point? So you're saying that you accept, I think, subject to your primary case, but looking at common law damages for two different injuries, you accept that there has to be an avoidance of double recovery. So there has to be some assessment by the doctor, by the court, of how much of the injury comes from both of them. But what you're saying is not currently needed, but is needed for option one, is to attribute that to one particular injury. But isn't the upshot of option one that actually it's all attributed to the whiplash injury as a matter of law? Well,
the answer to that is well, what is attributed to can't be an issue of law, it has to be an issue of fact. And the question as to whether or not well, the issue of fact is that it's concurrently caused by both the whiplash injury and the non-whiplash injury. But I think what the defendants say is that then, as a matter of law, you have to attribute all that to... Yes, well, I think it may be that we are, and it's my fault, slightly at cross purposes. So if once there has been, on the hypothesis that option one is legally correct, and on the hypothesis there has been a proper inquisition into causation as to whether it is attributable to A or B or concurrent, if the conclusion is that it's concurrent, then on my learned friend's preferred analysis, then what your ladyship has put to me is right. What I'm simply saying, however, is that if that is right as a matter of law, and I think it was really the point that was being put to my learned friend at certain times by my Lord Boroughs and perhaps to some extent my Lord the President, is that, and by my Lord the President, is antecedently to the determination as to whether or not there actually is a concurrent attribution, that is something which is going to lead to a factual inquiry which one has simply not needed to embark upon before.
But why not? If you have to do the Sadler stepping back, don't you then also have to work out how much is concurrent to make sure there's no double recovery?
Well, the first thing I would say is I would suggest that probably assumes a level of science into a Sadler adjustment which just isn't necessary. And I think the Master of the Rolls, Lord Wolfe, in Harlan Rankin says that one doesn't usually need to be sort of super precise about these things, because the reality is the court will look at matters holistically and it will know that somebody can't play football. It doesn't really matter as to what the precise cause of him not being able to play football is. That's the loss of immunity, and that will be factored into the overall global award. Now, of course, if the claimant has lost a leg, to take a much grosser injury, but he's also suffered some other injury that would stop him playing football anyway, I suppose at least theoretically you would have to take into account that when putting the injuries together there's an overlap of loss of immunity. But it doesn't require, in my respect for submission, anything like the same level of precision that one now needs. And of course all in the context of extremely low value claims, whereas I have said the cost of the medical report is itself extremely limited. And you can't recover.
So it's not that they're doing a completely different additional exercise, it's just the nature of the exercise. The nature of the exercise proposed by the defendants is different from the Sadler exercise.
It is different, it's more particular, and it also, I would suggest, is going to draw you into what I've called counterfactual questions in a much starker way than has hitherto been necessary. Because ultimately, I'm not sure. Mr. Weir has got far more experience of personal injury litigation than I do, so perhaps I should defer to him on some of these more on sort of practical issues. But certainly for my part, I'm not sure I'm familiar with medical reports that say he couldn't play football because of the constellation of injuries. If he had only suffered one of those injuries instead of both of those injuries, he probably would still have been able to play football, although it might have been a little bit uncomfortable. One simply doesn't see, as I understand it, anything like that level of analysis. And I'm sure your ladyship has my point, which I recognise as a sort of policy point. But I mean, the imperative for there to be that level of analysis is peculiarly objectionable in the context of the very forensic scheme which these whiplash reforms play a part. And it's why in my submission you can't just don a pair of blinkers and say, well, it doesn't matter about practical consequences, because consequences which are likely to be impractical and inconsistent with an accessible and cheap form of dispute resolution are likely themselves not to have been part of the parliamentary purpose, when the parliamentary purpose wasn't just about driving down damages, it was also making radical changes to the procedure itself. So our case on the cross-appeal will be a simple one. The argument by my learned friend is simply inconsistent with the limited scope of the legislation. Sorry, on the appeal. On the cross-appeal concerning the district judge's application of the totality adjustment or the Sadler adjustment, we will say that's wrong, because the legislation in our submission strips out the whiplash claim for distinct compensation under a different and non-commensurate or incommensurable statutory scheme, so that other injuries have to be valued separately. And we don't agree that leads inexorably to some overcompensation, and I'll come to why we say that. And also our proposition does have the virtue of simplicity, because it simply involves looking at the JC guidelines for the non-whiplash, looking at the tariff for the whiplash and adding them together. I've already suggested that simplicity isn't a make-weight, a sort of advocate's enticement in this context. It's actually itself a key part of the legislative purpose. So in the 5 minutes I have before the short adjournment, if I can start on my exposition.
Just before you leave that point, the development of the portal,
yes,
which came in at the same time.
Yes, roughly.
I'm right, that isn't restricted to whiplash injuries, is it?
Let me. I don't believe there are a series of portals, but I don't. It isn't. No, that's right. No, it is not. So within the portal, things can operate. The damages will be valued differently depending on whether they're whiplash or not whiplash. But the portal applies to any personal injury claim arising out of a motor accident,
yes,
where the personal injury element leads to general damages of £5,000 or less.
Right. Okay. So the point I wanted to put to you then was, if you've imagined this injured claimant with relatively low-level injuries in a car accident, I think you're putting to us, well, they're given the judicial guidelines and it's all very simple. But even the judicial guideline would require the Sadler adjustment once you've got multiple injuries.
That's true, and I'm not suggesting. I'm not suggesting that it is, like going into a Pizza Express and just looking to see what price different pizzas cost. It's not as simple as that, and the extent to which I'm thinking this is a process which members of the public can in fact navigate themselves, which the politicians seem to think was practical. But experience, I think the Master of the Rolls gives the statistic that actually fewer than 10% of claimants are litigants in person. So it may be that there was an element of, if I can respectfully say so to our colleagues across Parliament Square, an element of wishful thinking on the part of the legislators about this. I just appreciate your Lordship's answer, and your Ladyship aren't going to be assisted by anecdote. But I mean, just to give some scope as to how practical it perhaps is for litigants in person to negotiate this sort of thing without assistance. The official claims portals, the Official Injury Claim Services guide, which it issues for litigants in person, extends to 65 pages. So you make of that what you will. But yes, I'm certainly not intending to suggest that my preferred solution is some sort of a panacea which strips out any possible difficulty, and the claimant really can just choose two figures as if from a menu. I mean, it's not quite as simple as that. But on any view in my submission, it is a lot less traumatic than the level of analysis which the defendant's case leads to, which, as I say, even for us on this side of the court as experienced legal professionals, leaves us completely scratching our heads as to the provenance of the figures which, in front of the District Judge of the Court of Appeal, the defendant was contending for. I was going to come on to the legislation, but I am conscious that we've got about a minute left, and I just wonder if that's a natural point.
Yes, certainly, Mr. Williams, thank you. We'll adjourn there and resume at 2 o'clock.
Very good, my Lord.